afternoon and welcome to today's webinar hosted by the National Network of Credit and Financial Professionals. I am here today with Rafael Zahralddin, Shareholder Director and Elliot Greenleaf's Chair of the Commercial Bankruptcy and Restructuring Department, who will be presenting on what a credit professional should know about contracts. A few items to get out of the way before we begin. If you have any questions during the course of the presentation, you can ask them through the questions function on your side panel. We will gather all those questions and save them for Q&A at the end of the presentation. If you are looking for a copy of the slides, we will be sending a copy through email after the presentation is complete. The last item is that we will have a brief survey that pops up after the webinar ends. It only takes about 30 seconds to fill out, but gives us a lot of great information on how we can continue to make our webinars better for you. Now, Ken Frisco will give you a brief intro of our speaker.
Thanks, Roxanne. Good afternoon, everybody. Sorry for the audio difficulties. Just to give you a quick background on Rafael, he's a shareholder director and Elliot Greenleaf's chair of the Commercial Bankruptcy and Restructuring Department. He is a business lawyer who concentrates his practice in the areas of commercial bankruptcy and restructuring, commercial litigation, which includes construction, corporate employment, intellectual property and bankruptcy litigation, creditors' rights, corporate law and entity formation, international and comparative law, corporate compliance and related regulations, including under the Federal Corrupt Practices Act, commercial transactions, and cyber law. So I'd like to turn it back to Rafael to begin the presentation.
All right, good afternoon, everyone. So there's a picture of me in a bow tie, and you guys have read the overview before, so let's jump into credit managers and contracts. So you guys deal with contracts all the time. Often you deal with contracts that are set up or given to you after the fact by your sales function. A lot of times your contracts are a combination of several documents, and we'll talk a little bit about some of the issues that'll come up when that happens. You know, you'll have a purchase order, you'll have invoices, you'll send things out with prices on it. It'll come back in a different format on somebody else's form. We'll talk about what happens when you have that trade-off. And sometimes the documents will conflict with each other, and we'll talk about, well, what happens when you've got those conflicting terms. And then you're also monitoring the relationship as credit managers. And so non-payment, which is a breach, because you guys are normally the sellers, right? That's another issue we'll look at, and then we'll also look at whether or not there's any pre-breach remedies. You know, what can you do before you don't get paid? And then we'll talk about how contracts are dealt with in bankruptcy, which I know has been the subject of some prior webinars regarding contracts, so we're not going to focus on that. We're going to focus on the other pieces so that you guys get a little more of an in-depth and practical understanding. So there's a Supreme Court case. You guys will be happy to know this is probably the only Supreme Court case or case that I'm going to cite today. The rest of it's going to really try to be a little more practical than throwing case citations at you. But this is an important case, and it's been cited 1,000 times. It's very well known to bankruptcy lawyers, and it's an old case, but it's important for you guys to know because it really acknowledges the rights you have as a creditor. What it stands for is the proposition that unless you have a specific bankruptcy interest or provision to the contrary, your rights, whether it's pre-bankruptcy or post-bankruptcy, all come from state law and applicable non-bankruptcy federal law. Now, what do I mean by applicable non-bankruptcy federal law? Well, for example, some of you guys may sell perishable food. And if you've been in a bankruptcy or if you looked at it as a credit manager, when you sell perishable food, you're protected by the Perishable Agricultural Collection Act, which is known as PACA. That would be a federal statute that's been set up, and that, sorry guys, that is the federal right that pops up that would be controlling and would trump anything that's in the bankruptcy code. So let's talk about contract formation. There are 2 or more parties to have a contract. You have to have an agreement which consists of an offer and an acceptance. This can be a written, oral, or it can be implied from the conduct of the parties. And it requires something called consideration, which is a promise to do something in exchange for something that's a detriment to the other party or a benefit to the first party. So in other words, there has to be an exchange of one thing for the other. Then you've got, express contracts, which are written contracts, oral, or they're inferred from the conduct of the party. Somebody shows up, and you guys don't necessarily have to trade written paper, but if you show up and you do some work, or if you bring some goods over and then someone pays you for it, that can be inferred from the conduct of the parties. They don't have to be in writing, or they don't have to be spoken. Then there's something called a quasi-contract that says that even if you don't have a valid contract, the party can recover the reasonable amount of the value it gave to the other party so that the other party doesn't, they call it unjust enrichment, but then the other party doesn't get something for nothing, basically. And then there's something called quantum merit, which says even if you don't have a valid contract, you can recover in quantum merit because that's whatever the value is of rendering of partial services or full services. That's a classic example where a guy sits up on his porch, someone shows up, they mow his lawn, he doesn't stop them. Well, they didn't agree on price, but he didn't stop them, and so something should be paid to the guy who mowed the lawn. And this is more for background because you guys normally fall under the UCC, and as we'll see, there are very few times where you'll have to rely on a contract not being formed. So what's an offer? Well, an offer can't be an invitation to engage in commercial activity. So if you see an ad in the paper, unless that ad says something like first come, first served, or limited quantities up to X number and it's the first 100 people, there's no offer in that ad unless you have that special language in there. You can't have an offer be preliminary negotiations. An offer basically has to be pretty definite. And so I was talking a little bit about the UCC. You've got what's called, in regular common law, the mirror image rule. So if the contract is for services, acceptance has to be on exactly the same terms. If it's not the same terms, then it's a rejection of the original offer and a counteroffer. If one party performs, then the last shot rule applies, meaning that the last form that you got is the contract. So if you're trading back and forth with your plumber on quotes and how much they're going to give you, etc., it's a pretty harsh rule if you have to take the last form and that kind of wins out, because and it seems really impractical to apply that type of rule to buying and selling of goods. So the Uniform Commercial Code, the UCC, which is a model code that's been adopted by pretty much every state in the union, has a version of the UCC. And there are little pieces here and there that their local legislature, the state legislature, didn't take. But for the most part, it's pretty consistent. So the UCC, under Section 2-207, it talks about what happens when you have different terms and in one person's purchase order versus an invoice, and then what ends up happening. And it basically says that unless the acceptance is expressly conditioned on the acceptance of the additional terms, you have a contract. So what it does is it avoids having to look at quantum merit and looking at other kind of unjust enrichment theories. You end up with a contract that's formed, and then you got to figure out, well, what do you do with the terms that are in conflict? So if you're not merchants, if you're not both merchants, if you're selling to consumers, then the additional terms are never going to be part of the contract. They're dumped out. And that's a consumer protection issue. But if you're selling business to business, which most of you guys do, the additional terms become part of the contract unless the offer says you got to take my offer, take it or leave it. Okay? And then you got to figure out if there's an exception to that, and you know, do the additional terms change the contract in some material way that basically means that you would have never accepted it. And one example is, say, a broad indemnification term, where the buyer basically says, or sends to the seller, or vice versa, a provision that says if something goes wrong, if somebody gets hurt by this product, you're going to pay for all my legal fees, and you're going to take care of the person that's hurt. Those are such material changes to the contract that they are seen as an exception to this general rule. The other thing they look at is they look at something called surprise and hardship. So, you know, if all of a sudden you end up with an arbitration provision as opposed to your regular provision in your contract that says you're going to go into Delaware and your dispute will be resolved in the trial courts of Delaware, if instead there's an arbitration provision, which arbitration can be very expensive, and it kills your right to a jury trial and all kinds of other things. If that is something that kind of pops up, then again, that additional term won't be part of the contract. Now, if you have a problem with the surprise term that pops up, you've got to object and notify the other side in a timely manner under the UCC. You can't just come back a year later and say, hey, wait, well, hold on a second. This additional term was something I would have never agreed to. So how does this work out, practically speaking? Okay, so Company Alpha wants to buy canned and processed foods from Company Omega. So Omega sends Alpha a standard purchase order form with all kinds of prices and products and its standard purchase and sale terms. But it basically includes a term that says that disputes, any sort of lawsuit has to be brought within 90 days, any sort of informal, whatever, it has to happen within 90 days or it's gone. So Alpha sends back a purchase order for several containers of canned peaches and says, and that has a term in it that says that disputes have to be brought within 2 years from the date of delivery of the goods. About half the peaches go bad 120 days from the delivery date, and when Alpha sues Omega, Omega says, hey, you know, you're 30 days on the wrong side of this. We had a 90-day claim deadline. So under the UCC, they have this thing called the knockout rule. And since none of the exceptions applied, the contract's valid, but the two conflicting provisions are knocked out, meaning that neither the 120 days nor the longer year limitation is going to be in the contract. And then you have to go into Article 2 of the UCC, and the statute fills in the gap, and it has a default 4-year statute of limitations. And so under the UCC, Alpha loses and Omega wins regarding the limitations issue. Now, it's a problem in a sense because the UCC ends up giving you a term that neither one of you liked, right? So one of the ways to avoid the knockout rule, which is why this is important when you're forming up the contract. One, you know that you get a valid contract no matter what. So it's not that they're going to be able to get out of the fact that you had a relationship and a contract. But two, it gives you a default term that you might not like, and neither the other side might not like either. and you get a surprise result at the end, which no one wants. So the solution is to, send a quote and blame the buyer to submit the order, but condition on a sales confirmation signed by both parties. And that sales confirmation is something pretty simple. It just says, here are our terms, and we have to agree on this, and it has to be signed by both parties in writing. And a lot of you guys are engaged in e-commerce. You have websites. Anything that's on your website, that should also expressly state that, and in your emails, that formation of a contract for sale is conditioned on the signed sales confirmation. That way you avoid the knockout rule. One of the other reasons you want to avoid the knockout rule and the UCC filling in, and not just in this area, but in a lot of other areas in the UCC, is the gap fillers that are in the UCC are pro-buyer, not pro-seller. And you guys are going to be the seller for the most part, right? Because your credit manager is looking after the orders that have gone out, and you're monitoring relationships where people are buying from you. Some of the things that are very pro-buyer is they put in consequential damages. And we'll talk about the damages in a little bit, but that expands it out from direct damages when the breach affects the buyer. There's a long statute of limitations, so that means you've got hanging over your head 4 years. They include implied warranties of what are called merchantability and fitness, which means that whatever product you're selling is an ordinary person in the industry, it meets certain minimum standards. That's just another way for them to get more damages from you. And there's no limit on the seller's liability, which often you can do just by saying, your goods are coming as is. You're not going to get all these other damages. You have a short time to come back if there's a dispute. Anything that you would put in your contract to kind of limit it, it has the opposite effect if the UCC takes over because you guys didn't sign a signed sales confirmation. So let's talk a little bit about what are essential contract clauses. Often when I get a contract from a creditor, whether it's in bankruptcy or whether it's somebody who they're having trouble with, now they got to go back and really figure out what it is that they agreed to with this buyer, and which I know is not always your function, right? It's a sales function that handles that. But if you have a recurring pattern of problems, this is a good way to avoid them and to make both the sales function's job easier as well as yours. But these are essential contract clauses, and we'll go through them, and I'll give you some pointers on each one of them. If these things are pulled out, what you'll find as we go through this is that they're often to the detriment of the seller, and it really hurts the seller as opposed to the buyer. And look, that's because a lot of this stuff, if it's left out, you'll find that maybe the buyer doesn't intend to pay you at all, or doesn't intend to pay you on time, etc. And because the lack of a lot of these clauses makes it harder for you to enforce your rights against them. So choice of law, choice of venue, this is a clause which, I sometimes rarely see in the typical purchase order invoice contracts that you guys engage in the most. Sometimes I see them in a longer-term contract, but they do affect a lot. What they basically are is it tells you what state's law applies. You can pick Delaware, California, whatever, but it picks a state law. And if there's a dispute, where does the dispute go? And those are important because they dramatically affect the economics of pursuing a case. If you don't have these clauses in your contract, there is a 20-volume set called the Restatement of the Conflicts of Law, where the lawyers will then go spend money, sometimes $15,000, $20,000, to then figure out, well, which law applies. Because you're going to look at, well, where were the goods, where did they start from? Are the parties in different states? I mean, it's one thing if everybody's in the same state. That's fine. Then that state law is going to apply. But often you're going to be going across state lines or internationally or wherever, and not having chosen where this dispute will go means that there will be a legal dispute over where it is. And if you're a seller, you're trying to get someone to pay you back, you have to tack on to your legal costs that $5, $10, maybe $15 or $20,000 extra added cost, which often will make, depending on how much the other side owes you, will make the economics of the case not worth pursuing. There are substantive issues that apply, such as a limitations period. You know, the fact that this clause in particular is not put into a contract, I often think is a red flag as to whether or not the buyer is going to honor terms to begin with. Either they're not sophisticated enough, or they just don't care because they figure you're not going to be able to chase after them. An integration clause. There's a rule called the parole evidence rule. It's been around since 1833. And what it says is it says that you cannot bring in notes, sticky notes, scribbles on a pad, stuff on a napkin, other emails, other letters outside of the contract to change the term of the contract. In other words, whatever's in the contract is the contract. But there are ways to get around this rule, and that adds more legal expense. And it can also end up adding unwritten, non-contractual terms to the contract, which again is really never in the favor of the seller. The integration clause is there to exclude any exceptions to the parole evidence rule. It basically states in the document that this is the contract, and all other notes, whatever else may be out there, don't control, and it tosses them out. Because you can, in contracts, the beauty of it is you can agree with the other side to get rid of a lot of this other extra added legal expense in a dispute, as long as you put the provision in. If you leave it out, then somebody else has to fill it in, usually a judge, and that means people had to fight over it, and that means you guys had to pay lawyers. And while I like to make an honest day's living, I'd rather not do it on something like this where you can avoid having to pay it. There's a related clause that says that, you know, modifications are only in writing. If this is related to the integration clause, sometimes it's part of it. It adds flexibility so that if something pops up, you can go ahead and say, okay, you want to have some more stuff, maybe it's slightly different terms, or, you know, maybe whatever other, you know, good they want to buy from you, but they don't want to have to redraft the contract. This just makes sure that any changes to the contract, you can use the old contract and the old relationship, but then any changes to that contract have to be done in writing and have to be signed. So it basically means amendments have to be done in writing. Indemnification is something that is sometimes in contracts, sometimes it isn't. It depends on the type of good often that's being sold. You can imagine anything that might hurt someone, lawn tools, food, you know, certain times, particularly foods that aren't pasteurized, things of that nature. An indemnification clause is basically a risk allocation clause. They can be used to help set fault at a fixed amount. They can be used to protect against being dragged into third-party litigation. And they often offer protection for third parties such as officers, employees, agents, related entities, etc. So they're important. They're a little bit complex. I'm not going to go into them in detail, but just realize that they're there, and they're, depending upon what your product is, oftentimes indemnification provisions are brought in. Again, this is usually for higher risk type of products, but it's something to be aware of. Force majeure clauses, these would probably be, in y'all's world, would probably be more of an issue if you have supply contracts. If you're supposed to be providing a certain minimum amount you know, whatever you're selling, whether it's widgets or perishables or whatever. And this helps to provide some sort of excuse from performance if you have fires, explosions, strikes, terrorist activity, other acts of God that are out there, like weather, hurricanes, earthquakes. And parties are excused from performance as long as the event continues often. And then if the event continues for too long a time, then the contract's going to be terminated. So again, this is another important clause in a contract. I just included this in here because I thought it was a good quote for kind of helping to wrap up, from the seller's point of view, is that, if the product goes wrong, they just repair it, replace it. They don't want anything more. They don't want to be dragged into lawsuits. They don't want any of that type of stuff. And that's usually what a lot of the clauses before are set up to limit. That's what the indemnification clauses do. It's what the force majeure clauses do. Again, if you end up adding much more liability if you don't put in these clauses to limit things, you lose your lines of defenses of just being able to say, look, I sold you the product, I want my hands washed to this, and I'm out. Instead, it'll drag you into all kinds of other nonsense, and oftentimes there may be something that was modified by the buyer, maybe that the buyer didn't maintain things, et cetera, et cetera. Maybe something that's not your fault, but you're going to get dragged into it unless you put in these different provisions in your contracts. So let's talk about the damages and the types of damages. You have direct damages. These are the ones that naturally and necessarily result from a breach. They're foreseeable at the time the contract was made, and it's by a reasonable, ordinary, and prudent stranger to the transaction. So it has to be something that somebody coming from the outside looking at it goes, okay, if you didn't deliver, eggs and milk and toast to that breakfast restaurant down the street on time and in the right amounts, they're going to lose customers, right? That's somebody from the outside can tell you, hey, I get it, that those are the direct damages. Incidental damages are costs incurred by the non-breaching party. Those are things that happen. In my example with the breakfast store, they had to go out and get eggs from someone else, and they cost them more. Well, that delta between what it cost me to make sure I had eggs for my customers and toast and milk and everything else, that's what would be a damage. If you send somebody goods and there's nothing wrong with them, but they still send them back for whatever reason, the cost of carrying them back to your place of business would be a damage that you would get as a seller. Consequential damages are those that aren't necessarily obvious without communication of other party circumstances. They're kind of things that happen that were a little bit unexpected. One important thing is that a lot of times people will tell you that lost profits are consequential damages. That's just not the case. Lost profits are something that are direct damages. And again, as you'll see in a little bit, direct damages are a lot easier to prove, and they pretty much come as a result of a breach. It's when you get into consequential damages and things that are harder to kind of tie in to the breach that it takes a little more money to get them proved up, and they're the ones that end up going first when you're trying to settle something. So one of the clauses in a contract that deals with these types of damages, they are called a liquidated damages clause. And it basically, it says that if there's a breach, and it's a breach related to non-delivery or whatever it may be, this is the amount of money it's going to cost if you breach. You have to make sure that that number is reasonable. It has to be tied to some sort of commercial justification. And what happens if you go too far with them is the court will say, you know what, that's not a liquidated damages clause. That's a punitive clause. It's a punishment, and we're going to invalidate it. You don't get any money. So what it helps to do, and a related clause to this, or part of that liquidated damages clause, is that it helps to kind of give you the universe of what happens if things go wrong, and it will help to set a price on the consequential damages that are out there so you don't have to fight about them later. So as long as you can come to a commercially acceptable amount for consequential damages and you put it in your contract ahead of time, you don't have to pay lawyers and then essentially go to court to have a judge determine what they are. And the UCC has some clauses that address both incidental and consequential damages. So the UCC allows you to limit or exclude consequential damages, and the only limitation they put in there is that the limitation can't be unconscionable, so they don't want people abusing the power because of superior bargaining power here. But it's really difficult to say something is unconscionable if two commercial parties come to agreement on it. And the UCC definition for consequential damages is similar to the stated common law definition that was on the slide before. Incidental damages are defined in the UCC as well. They're the kind of expenses you get when you're inspecting, receiving, transporting, caring for goods, etc., that were rightfully rejected, and any sort of other commissions or expenses with affecting what they call cover, which is what I talked about before. You know, if I have to, if let's say I can't get certain eggs to people, but I can go out there and get eggs on the secondary market and bring them instead then, you know, the difference for that would be an incidental damage. And really any sort of other reasonable expense that comes up with dealing with a delay or any kind of other breach. The UCC defines consequential damages. Again, it's the same type of definitions we had before. It's something that's foreseeable and which couldn't be prevented by cover or otherwise. And then, of course, the second piece of this, which, again, really deals with certain types of goods, or injury to a person or property approximately resulting from any breach of warranty. Because contracts also have warranties in them, so if there was a violation of the warranty and there's some sort of damage, this is supposed to help limit the type of damages you can get from the breakdown of a product. We talked a little bit about risk of loss. That's also covered by 2509 in the UCC. The basic rules you guys are probably familiar with. A lot of the things like FOB and the other INCO terms that set risk of loss when the risk of loss on the goods transfers from one party to the other. If you've got no destination designated, then the risk of loss passes to the buyer when those goods are delivered to the carrier. If you have a destination designated, then risk passes to the buyer when the goods are delivered. With bailments, it depends upon when you get your negotiable document of title, or the bailee acknowledges the buyer's right to possession. It's really a possession-driven thing, and possession with some types of goods in a bailment have to do not just with physical possession, but possession of the actual negotiated document. With leases and non-conforming goods, in an ordinary lease, a risk of loss is retained by the lessor. In a finance lease, the lessee gets the risk of loss. If you have goods that are non-conforming, meaning the goods weren't as they were supposed to, the risk of loss stays with the lessor or the supplier until the problem of the non-conforming goods is cured or the other side accepts it. Sometimes you have insurance clauses that require the company to maintain insurance to cover claims against the buyer or the seller. This is a lot like an indemnification provision, except for you're having a third-party insurer cover the cost. Termination. There's two types of termination, generally speaking. One is having a certain ability to stop the contract. The other one is really more of a term put into the contract, whether it's 2 years, 3 years, etc. A lot of you guys that deal with invoices and purchase orders, you don't really need to worry about that because your term is really just as soon as you deliver those goods. If, however, you've got master services or master credit term or master conditions and clauses out there, and there isn't a term put in there, or it's not explicit that this doesn't create a long-term contract, sometimes you can get wrapped into a contract you didn't know existed. But these are, termination. Normally it's for cause. Normally you have a notice period to cure the breach. If the breach isn't resolved during the cure period, then there's another notice required to terminate the contract. And then the termination occurs once you've completed your duties under the contract, including notifying folks. There's also termination for convenience provisions, and there's always some sort of time period in there so that the other side has some time to adjust on the contract. And look, sometimes what they're trying to do in the law by having these termination clauses written this way is make sure you don't end up throwing away a contract just because there's a misunderstanding or a missing check in the mail. Waivers, these clauses are there to show that just because you don't enforce a term in the contract one time doesn't mean that you're saying it's okay for the rest of the time. And that happens. Under the law, there is a doctrine of waiver that if you keep on accepting rent payments 10 days after the day the rent's supposed to be due, that you basically waived the earlier date and any interest in between if you do it often enough. Same thing here, and what these contract provisions do is they say that, look, just because I slip up once doesn't mean that the contract provision is waived. It just means you got away with something that one time. Attorney's fees and costs. This is another important provision in a contract that oftentimes people gloss over. The rule in the United States is that the parties pay for their own legal costs unless you put something in your contract or there's a statute authorization under state law usually, that's very particular. You'll know when it's there. But the first one's pretty easy. If you put it in the contract that if they don't pay, you get attorney's fees and costs, that's the contract term that they have to abide by. Some state statutes will limit the cost to reasonable fees or put a cap on the attorney's fees, but that's a state-by-state type of thing. And again, that kicks you back in to make sure you pick the right state. Some states may put a limit on fees and costs. Other states may say, no, if you agree to pay the other side's attorney's fees if you lose, that's what it's there for. And you guys, I'm sure when you deal with folks that are credit collection attorneys, that's a provision that's important that's out there, whether it's by statute or whether it's authorized by contract. There's something in the law called an offer of judgment. And one thing to remember here is that's where you basically go to somebody before you go to trial and you say, look, I'd like to settle for $15,000. And if the court then finds that they were you were only liable for $10,000 and they didn't take your better 15 offer, then they have to pay for your costs. That does not mean attorney's fees. It might mean expert fees, might mean plane tickets, might mean hotel, but it's not going to be the bigger ticket item, which are attorney's fees, which a lot of people don't understand. UCC remedies. So don't wait until a creditor files for bankruptcy. Under the UCC, you've got a bunch of things you can do, and your options once they file for bankruptcy, as you guys probably know, get significantly reduced. You can do a lot of different things here. You can do what's called a demand for adequate assurance of performance. This can come from from news, from gossip, from almost anything, at least in the beginning, and then you can go out and kind of solidify it by getting it from harder sources. But you can always do this demand. One of the examples is if you find out that a company that is out there that they've got bond payments coming due, and that's going to put a real crimp in their cash flow. If you see that, you find out that they're using alternative financing like factoring because they've got cash flow problems. Sometimes you'll get somebody will tell you that your contact there. Oh, we've got this, we got that going on. Post-dated checks. You hear that they've lost either credit or insurance that was withdrawn from them. All these things are a basis for this demand of adequate assurance with performance that I'll talk about. So what's an adequate assurance request? This is an alternative to exposing your company to a potential breach because you stopped delivery or you've switched to cash advance. 2609 gives the seller the right not to have the expectation of receiving performance or payment impaired in any sort of way. And you need reasonable grounds for this insecurity. You need objective facts. It can be outside the contract. The grounds must be based on actions that have occurred post-contract formation. Reasonable commercial standards are always used. The third-party sources have to be credible, right? It's okay if the gossip's coming from their sales department, for example, as long as you make sure that you're getting the right info and the parties are credible. And you have to be careful. Sometimes people start whispering things in your ear, and it may be that they have their own commercial reasons for putting out bad information because they may sell a similar product or maybe trying to get your business. The request should be in writing. It should reference UCC 2609. Don't water down the language because you don't want to hurt people's feelings. Make sure you're very, I don't want to, you don't have to be rude certainly, but you have to be factual and forceful. You got to explain the basis for the insecurity. We heard that bonds are coming due. We read in the papers that this plant's being shut down, whatever it may be. And then you have to demand the adequate assurance. We'll talk about what that means. And you have to state that repudiation of the contract, basically saying that we're not going to supply anymore, is a consequence if they don't respond. What are the types of adequate assurance? You can tell them to post a letter of credit. You can tell them they have to switch to cash advance. If you did it without doing the adequate assurance request, you might be violating the contract. You can tell them to get a third-party guarantee, or you can have written confirmation from them, and they're going to fix the problem. Any of these things could be adequate assurance. But what they do is they provide you the cover to then breach if these guys don't come back. Because sorry, I put once in there twice. You've issued the request for adequate assurance. The seller can suspend performance without breach. The buyer then has, so in other words, you can stop supplying. Then the buyer has 30 days to respond. And if there's no response, then the buyer, their contract is repudiated, and the seller can now pursue the buyer for breach. Sorry, I don't know why this slide's a little bit off. At that point, you've issued your request for adequate assurance, and the seller can suspend performance without breaching the contract themselves. So what are the practical benefits of running through this dance of adequate assurance? First, you're going to be minimizing risk of loss. You get to take steps to cover the loss when it appears your client is no longer creditworthy by asking for things to make up for that. You get to negotiate instead of litigating the dispute, which is usually less expensive because it doesn't, at most maybe you have to get your lawyer to look over the draft of the letter that you send out, etc., but it's not as if you're having to go actually out to chase them. And if you exercise repudiation, that prevents a debtor in bankruptcy later forcing performance on the seller while they decide to keep or reject the contract. In other words, it acts as a way to end the contract, which, a lot of times you'll have an executory contract in a bankruptcy and you'll be forced to continue to perform. can also get your goods back, as you guys know. You can stop goods in transit under UCC 2705 as long as the buyer hasn't taken possession of the goods. It's got to be actual possession, not even risk of loss where it goes to the carrier and then the risk of loss transfer. That doesn't matter under this particular provision. If you have a bill of lading, which is negotiated and in possession of the buyer, goods can't be stopped in transit. That's a little bit different. But then again, that's very similar to what we talked about before. If ownership or possession is not by physical possession, but by possession of a document, that's consistent with the negotiated bill of lading. You have to notify both the buyer and the party in possession, the carrier, the warehouse, etc. And the seller is responsible for any damages relating to stopping delivery, and the seller can hold the goods until they get paid. Bankruptcy does not halt stoppage of delivery. That does not violate the automatic stay, but you got to be careful. Don't do any more to force return of the goods outside of the bankruptcy remedies. But if you get to it and they haven't transferred over to them, you can certainly pull them back, and that does not do it. But if they have them, or if they have possession of them, or there's any sort of issue and you have to be a little more aggressive, that's where you got to be careful and you got to talk to a bankruptcy lawyer. You'll have to, if they won't return the goods, for example, you need to file an adversary proceeding in the bankruptcy court to get them back. Other thing to watch is a debtor may come in as a first day motion or otherwise as an emergency motion and say, hey, you know what, we know we're going to have trouble with people stopping goods in transit. We want an emergency order. You need to be there to object to that. Or 10 or 30 days later, you need to be able to come in when you have the most emergency orders. There's a time period where you can come back and have them reconsidered when notice has gone out. You've got to go in there and fight that, particularly if you've got a large set of goods out there that were stopped, and they're trying to use a court order to keep the goods flowing, which is one of the reasons you should always be aware if somebody's filed and what they're filing on those emergency hearings. You guys know about reclamation. That's governed by 2702, and then once the bankruptcy is filed, it goes under 546 and some other provisions which trade off being able to actually get the goods back to really getting an enhanced claim in the bankruptcy. To do reclamation as opposed to stoppage, the buyer has to be insolvent. That's why the two things are different. The creditor has to make a written demand on the bankruptcy. Under the UCC, you get 10 days. But if you ask for what's called a statement of solvency within 3 months of delivery, which can be part of your adequate assurance request that I talked about before, then that 10-day period doesn't apply, and obviously the buyer still has to be in possession of the goods for you to be able to reclaim them. They can't have gone out to other folks. Anticipatory repudiation. Anticipatory repudiation is where a party communicates that it intends to breach. So if a buyer tells the seller they're not going to pay for certain goods that are pending delivery, then the seller can then exercise any remedies it has, including suspension of performance. The buyer can call back a repudiation and say, hey, I didn't mean it, but that has to be in writing, and it certainly can't be something that is indefinite. And if there are any sort of damages, those have to be out there. So again, it's very important how you communicate and what you communicate to a buyer that you believe is in trouble, because the second that they come back and say, well, we don't think we're going to pay for this, that's where you can sit there and say, okay, well, now I need my goods back. You're basically saying that you're not going to look. You're into the contract. Contract's over. Give me my stuff. And the timing on that is pretty key, as you guys know when you've dealt with bankruptcies. Just end off with, like I said, you guys have heard about executory contracts before. That's why I wanted to cover other pieces of this. But just as a quick primer, once you get into bankruptcy, you have a contract between the debtor and another party, and whether you still have things to do, you have an executory contract. Some examples are commercial real estate leases, equipment leases, intellectual property licenses, but you guys know that sometimes if you have something floating out there that gives prices and doesn't give a term, a debtor will say it's an executory contract and you have to keep on supplying to me. Oftentimes they'll do that even though they owe you a ton of money, and they'll do it even though after looking at their books that they may not be able on a go-forward basis to pay you even after the bankruptcy has been filed. And as you guys know, the reason that these contracts are important is that the contract can be assumed, rejected, and there's something called a cure. So the debtors can pick and choose contracts that are deemed executory as to ones they'll keep. Sometimes they'll keep them and give them to somebody else. While this decision process is going, the non-debtor has to continue to perform, even if the debtor is not paying them. If the debtor assumes the contract, the good news is that you have to cure or come in compliance with the contract, meaning that you have to pay all pre-petition debts, and that way you can get 100 cents back on the dollar or some other thing you negotiate. But if the debtor rejects the contract, there's a breach, but the damages will all be unsecured claims, and any unpaid amounts that you didn't get, you got to go back to the court and prove that they meet up with being an administrative claim. And an administrative claim has to benefit the estate. That means you have to go to a judge and say the stuff that I sold benefited them. And oftentimes judges will change the terms of the contract. They'll say, well, yeah, you benefited them, but guess what? We're going to mark down the pricing on this because it wasn't market value. And the other side, the debtor will put up evidence that they could have gotten the stuff cheaper from somebody else. Okay, that's the end of the presentation, and certainly I'll look to see if there are any questions.
All right, Rafael, you ready for your first question?
Sure.
All right. Can you talk a bit about 503B9 bankruptcy claims? How prevalent are these claims, and how successful are they?
Well, 503B9 is essentially the other part of the bankruptcy code that deals with reclamation claims often. 503B9 claims are I'll tell you a couple different things that happen with 503B9. First, when you have a 503B9 claim, you obviously are elevated above an unsecured claim, and you're an admin claim. Most of you guys are familiar with the distribution scheme under the bankruptcy code, which comes from, under the Buettner case, comes from state law, right? The bankruptcy code tells you that secured claims get paid in full, okay? And then think of it as milk buckets on a set of stairs. Once the milk bucket for the secured claims is full, you can pour milk into the next level, which is the admin claim or administrative claim bucket. That bucket needs to be paid all the way to the top, and then unsecured claims get next, right? And we all know that that bucket never gets filled up to the top unless something miraculous happens. And then at the very bottom is equity, people that own stock, shares, right? And if the unsecureds are paid at 100%, then they get something. And that's a traditional distribution scheme. So a 503B9 claim is an administrative claim. So it gets paid at 100 cents before any money goes to the unsecured claimants. The problem is sometimes you're so bankrupt that those don't even get paid. The good news is that in order for the bankruptcy to keep going forward, and bankruptcy lawyers, the debtors lawyers committee, et cetera, they have administrative claims. So do the people that lend to the bankruptcy, because those are the things that help the bankruptcy train keep rolling so that something ends up spilling into the unsecured claimant's bucket. That's a justification for it. But to be an admin claimant, oftentimes, post-petition amounts are paid out, and 503B9 is a particular statutory claim that's also paid out. What I've seen is that as long as you get to a plan, meaning that they do a plan confirmation process, the 503B9s have to be paid. So if you've got money coming in and they want to get a plan done, and a lot of times people want to get a plan done because the owners of the company, they get releases meaning you can't go after them for bad things that they did during the, aside from avoidance actions and fraudulent conveyances. In general, they want to get releases so you don't sue them. And in exchange for that, they'll get a plan, because you can do releases in a plan. And when you do a plan, you have to pay all your 503b9s in full. People can take less, though. And this is the second piece that I'll tell you about. Critical trade vendor orders that I've seen, particularly in jurisdictions that aren't as liberal with critical trade like New York or Delaware. Oftentimes, critical trade vendor motions are now not, I'm going to pay your unsecured amounts, because that's too much of a cash flow issue for me as a debtor. But what I will do is I'll pay you 70 cents on the dollar for your admin claims, and we'll agree to them, and you'll make sure you get them now instead of in the future if and when we do a plan. Because there's a chance we're not going to do a plan in this case. There's a chance that we may just sell the company and then convert the case into a Chapter 7, in which case your admin claims, your 503s, would never get paid. So if you continue for the pendency of the bankruptcy to provide me with the same credit terms I had before, and you take 70 cents on the dollar, and we'll continue to pay you, and those have to be paid as administrative claims will be allowed, then I'll pay your 503b9. So I've seen that happen as well, and that's been more accepted in jurisdictions where they don't even do critical trade, because it doesn't violate. The problem with critical trade is it starts to pay off other unsecured creditors over people that are higher up in the distribution scheme. So I don't know if that helped to answer that question, but I think that 503b9s can be very successful, but it always depends on how much money is in the case and how the case is being funded. There were a lot of people, for example, in Circuit City that had admin claims or had 503b9s and admin claims that took a bath because that case collapsed without any financing, and then became a slow burn liquidation over 3 or 4 years.
All right, Rafael, you ready for the next question?
Sure.
All right. What if a vendor's contract includes key market funds or co-op? Is the vendor still obligated to pay key market fund co-op if the buyer files bankruptcy and there's nothing specific stated in the contract?
Well, if there's nothing specifically, I'd have to look at the contract, obviously, because, and that sounds like a very specific, almost legal advice type of question. But let's just say hypothetically you have provisions that are not in the contract and are not referred to directly outside of the contract. I said before that, you have integration clauses that say this is the only contract. If you didn't have an integration clause in that contract and you had other secondary agreements all over the place where there was a good argument that the contract's not what's in front of you and there's no integration clause that says it's only what's in this, 10 pages or whatever, you could go to court and you could force someone to, like in a bankruptcy court, the debtor could walk to the bankruptcy court and say, the contract was this and this and this and this, and there's no integration clause, and these people agreed, and here are the emails that followed the telephone conversations, that followed the in-person meetings, etc. So there is a chance that you might be able to, and again, these are all very fact-specific examinations. So without answering that specific question, because that gets very close to providing legal advice, so I'm happy to talk to whoever that had that question in kind of a consultation, a free consultation type of mode. They're welcome to give me a call. But that's the type of situation where having something like an integration clause in your contract would prevent someone from bringing in other terms that you guys didn't necessarily agree upon.
All right, Rafael, I actually have a few more questions, but due to time constraints and the fact that we ran over the hour, I'm going to give you one more. Would it be okay if I provide your email address later and forward you along these questions and you can answer everybody individually?
That's fine. And they have all my information up here too, so they're welcome to. And I'll clean up a couple of the slides that seem to have gone astray, and then get you guys a new slide deck too.
Absolutely. All right, I'll give you the one more question. Okay.
Sure.
Regarding adequate assurance of performance, what established standards, norms are commonly used as a guide to having reasonable grounds for any doubts on performance?
I think it has to be things that are accepted in the industry, okay? Because they're looking at what is reasonably commercial. They don't want to just have a list of things that are the only things, right? But you guys rely on all types of things in the industry. I've talked to you guys, and I represent credit managers, so I know, right? So you'll have the paper. You'll have particular trade publications. You'll have particular trade publications that are tracking things like bond payments and when they come due. You'll have insurance and other publications talking about how certain things are uninsurable and they're withdrawing insurance. You'll be able to, with a lot of the tools you guys have, you can tell if things are being factored. You can tell if there are new lenders that have popped up. You can tell if there are other things that are more macroeconomic that are affecting the industry. You guys have a whole panoply of stuff that you look at, but you always keep your ears open, and you guys always tell me, hey, you know what, I heard this from sales. It can't just be that I heard it from the sales guy over there, or we were out at a conference and somebody told me these guys are, it can't always be that, but that's where your inquiry starts, and then you look to see if there's anything that's concrete out there. And you know, most of the time, as long as it isn't, I think you can be wrong commercially and it doesn't hurt to ask, but what you have to be careful of is if somebody's feeding you something that is obviously being motivated by a nefarious motivation by that person. So if it's a competitor and you don't kind of sit there and look at him and go, wait a second, you're a competitor to that guy, you're just trying to get my business. Those are the types of things where people said it was unreasonable to rely on it as your basis for insecurity under adequate assurance. But you know, it's very fact specific, and as long as you find some other basis that's objective and commercially reasonable, it doesn't matter where you get your tip, right? And then it really just ends up being something you add in on a laundry list of things after you've done some due diligence and send it out there.
Well, thank you, Rafael. With that, we are actually going to close today's webinar. I would like to personally thank you for taking the time to present to our group today, and thank all the attendees for taking the time out of their day to join us. Thank you all again, and we look forward to seeing you at our next webinar. Goodbye, everyone.
Bye, guys.